Welcome back, ladies and gentlemen, to our conference, The Role of the Judiciary in the Economic Development of the State, where we are discussing with industry specialists the current issues and related to improvements that can be done today to help the judiciary go hand in hand with economic development to improve our general well-being and prosperity. And we've come to the third panel with the effective investigation and prosecution of financial and crime. And as before, we have a very interesting panel with Ines Egise of the State Police, Igor Gerasims of the Prosecutor General's Office, and Amit Kabravala of the Embassy of the U.S. Embassy in Latvia. And in keeping with the pace that we've had so far, we will now give the floor to our panelists first, and then we will proceed with answering the questions that you send in to the telephone number 28346531. So please do send in your questions. We've answered so far all of the ones that we have received. So first, I give the floor to Ms. Gise from the State Police for her address to the conference. Hello, dear participants and listeners of the conference. I am here today representing the State Police and the Department for Investigating Economic Crime. And I am here today to speak about the current events in financial crime investigation, more specifically regarding money laundering. Based on the speaking points that we were received as suggestions, I'd like to speak about investigating financial crime in the context of reprofiling of crimes and technological development, how we see possible cooperation moving forward with other institutions and in the investigation of financial crime. As regards investigating financial crime in the context of the general development in criminality and criminal application of modern technologies, I would like to say that the State Police is ready for this. The State Police has defined priorities in this regard as regards economic crime prevention department. This is the highest structural unit in this regard. The State Police has managed to find the best specialist for investigating financial crime, but at the same time, as regards investigation of money laundering cases that my unit specializes in, the investigator cannot be a specialist in absolutely all areas. So it is very important to be able to involve necessary experts in the investigation. I'd like to take the opportunity to mention that I participate in the Moneyval evaluation procedure as well as the OECD recommendation process. And we did receive some notes on the lack of efficient interinstitutional cooperation. This year, I can say that we have definitely improved our cooperation. We immediately brought in the Financial and Capital Market Commission in financial crime investigation. And we've brought in the Financial Intelligence Unit from day one. We have been cooperating with the supervising prosecutor from the prosecutor's office from day one. We also involve experts from the insolvency administration. We speak with the Finance Latvia Association. So today, I don't see any reason for concern as to any lack of interinstitutional cooperation in this regard. I'd also like to encourage our investigators to bring in experts more often. Don't be shy. As an investigator, you cannot be an expert on absolutely everything. So that would be about cooperation. As regards communication with the public, regarding prevention of crime, how to be a step ahead of crimes being performed, how to have this police and the public understand this. I'd like to raise a very painful issue. If we look at what we hear on the news, what we hear people talking about on the streets, we have two major issues, and this is my personal opinion, that both of these issues are very similar, if not identical. Meaning, first of all, certain individuals have raised the issue of human rights being breached in regard to the need to wash your hands and wear a face mask. At the moment, obviously, this is a difficult time for the world and Latvia as well in the context of the COVID-19 pandemic. And it is we have to ensure the interest of the public at large. We have to strike a balance between public health and not overburdening hospitals. And another issue that is very painful and is often raised is the need to abide by the criminal procedure law, that when the process administrator has proved that certain property has been illegally obtained, for the party involved to be able to prove the legal origin of their property. So people often see this as a breach of their rights, although here I see a similarity with the COVID restrictions. So if we allow the same situation to ensue as we had a couple of years ago, I have experienced this myself in the Moneyval and OECD recommendation process. So we were just one step from being included in the blacklist. So I personally think that we have to understand that if we don't abide by certain rules, then we will find ourselves in the situation where we'll have overburdened hospitals with COVID and overburdened justice system with the other issue. So in the end, we won't be able to handle this immense volume of money laundering cases that we used to have. So it's difficult for me to answer these rhetoric questions about justice or fairness. I am an employee of the state police, but at the same time, I'm a member of the public. I'm a mother, I'm a wife, I have a personal life. And personally, I don't have any problem. I don't feel as if my rights are infringed upon by being asked to wash my hands or explain the legal origin of my property. At the moment, we are actively working with the Prosecutor General in creating a joint understanding and guidelines. We will have a very important training session next week focused on educating our investigators, prosecutors on what money laundering actually is, what the main problems are in this area, how to understand the more problematic issues pertaining to the latest amendments to the criminal procedure law. And here, two articles are very important, which I'd like to focus on slightly here. Again, addressing judges. So Article 124 and Article 126. I'd like to stress again that the investigators investigating financial crime today are truly the best. They are doing their best. We are at the same level throughout the whole system. We have been to all possible seminars, training sessions. We've gone even above and beyond in many issues, because if we compare the situation to 2015, when OECD first mentioned that Latvia has immense problems with money laundering, and state police was the first to give a signal to the Ministry of Justice that we have problems with investigating money laundering cases. So we can investigate this. We do. We understand how to do this. So Article 124 and 126, it's very important to understand that we never go up to a person in the middle of the street and just out of nowhere ask them to prove where their car came from, where their apartment came from. This is very important to understand this. We abide by the law. First, we have a criminal case. First, we have an investigator that proves an assumption that the property is most likely obtained illegally, and only when a body of proof has been established that there is a very big likelihood that the property is illegally obtained, and then we establish this act saying that the owner does not agree with the illegal origins of this property. Only then other actions are taken. So it was said here today that judges should be more courageous in taking decisions in cases where case law is only being developed, where we have very few court decisions so far about deeming property illegally obtained, or decisions on money laundering cases as a crime in itself. At the same time, last year I had the honor of speaking before a great many judges. It was called a training session, but right from the outset in my address, I said that I would never venture to train or try to educate judges. I would simply explain to them how we investigate money laundering cases, and we described what we do, we described our procedures, and I was moved to tears that the judges applauded us, that we were able to convince them, show them that today, if we speak about customary law, then we should move away from this mindset that the state police is on the lowest step of the system, that the police is uneducated, that it cannot do anything. We can, we do, and we are very much willing to discuss issues with the prosecutor's office, with the Ministry of Justice, with judges if they want to have a discussion. So that would be all for me at the moment. Thank you. Thank you, Ms. Giese from the State Police, for opening up several questions that we will continue to look at in the further discussion. Now I give the floor to Mr. Gerasims from the Prosecutor General's office.
Hello, colleagues. Hello, colleagues. Hello, all the people present. Thank you, Ines, for opening this part of the seminar. Thank you for this opportunity to be also here remotely on behalf of my colleagues, regardless of the circumstances. My name is Igor Gerasimins. I represent the Prosecutor General's office. And what Ines started from the state police side, I could agree that the national economy could not develop without efficient investigation of economic crimes, financial crimes. And what has been done already by all our cooperation institutions, including FIU, we have to look back where we were, which we had to get out of, and that in a comparatively short time, a year and a half, which is not long, we had to prove to international experts that we can do something in this area, and we've achieved great progress. I have to mention Moneyval, already mentioned by Ines. We were both represented in this evaluation process, as well as in conclusions mentioned by OECD. They came up with specific recommendations that had to be implemented and that we are implementing. If we are speaking about strengthening of judicial authority in combating financial crimes, there are three things that you can measure it with. First of all, a modern and understandable legal framework. In the morning already, Mr. Minister mentioned that regulatory framework has to be applicable and simple, as well as quick procedure of investigation and litigation and prosecution of financial crimes. And the third pillar is that the society should be able to understand these processes, why things are done this way. And if we look at procedural parts, what are the measures to be implemented? I will tell you what is being implemented in order to fulfill our mission. First of all, I have to mention legal framework and making it better. I don't want to say that that legal framework regarding financial crimes is bad. No, it is rather good, but all legislative authorities could amend it and make it better. We do have discussions as to civil law confiscations, as well as other solutions that could make processes swift and efficient. And here, Prosecutor General and its office is involved in very actively and takes part in committee meetings of our parliament. Prioritization in institutions, it is very important. And it was 2018 when OECD experts were here, and they said resources will always be limited, and no institution is so efficient that will be able to investigate 100% of cases. That means all resources have to be prioritized according to priorities. And what are the risks in respective country? We have defined our risk profile. It was elaborated by FIU. We have identified those financial crimes that are threatening our national economy, and according to that, we lever our investigations accordingly. For example, money laundering is of our utmost priority. Prosecutor General has paid great attention to that. We have cooperation with state police. We have delegated people working only on these issues, working on unified practice. This is a priority, very significant priority. Also, I have to mention tax and customs issue, which starting from this week, our prosecutors will start cooperating with tax and customs in order to make it even a bigger priority. Also, it is also important to prioritize during the litigation processes. If we will ensure the application of law, namely that litigation is on timely basis, penalization is on timely basis, that will make clarity and transparency on those cases. Interinstitutional cooperation, strengthening of it, a very important aspect as well. Combating of financial crime is not just an issue of state police, of Prosecutor General's office. It is a cooperation between institutions and can only bring fruit if we work together. Lately, we talk a lot about this platform, investigator, prosecutor, court. We meet in several training courses, and Madam Gies already mentioned that next week we will have training organized by FIU. Tomorrow we have panel discussions between judges, prosecutors, and investigators. Those are ways how we can foster understanding. We have cooperation memorandums, agreements, we have guidelines how to prioritize crimes in order to investigate them better. There are cooperation platforms where we work together on making our legislation framework better. So interinstitutional cooperation is there. Even the cooperation between investigators and prosecutors. From my experience, I can reconfirm that I meet with police every other day in order to discuss important things for the cases. One other aspect, specialization. Financial crimes are developing and obtaining a new face, and we have to develop with them. And it can be done by specializing in combating money laundering. We will have a specific or specialized court that was already mentioned. Education of society, informing society. Informed society trusts judicial authority more. And other institutions like Prosecutor General's office and other institutions does a lot in order to inform the society as to what is happening in any given case, in any given processes. During litigation time, judges are telling about the case, about their decisions, etc., and explaining them. Maybe the society not always agrees with judges, but being informed, it's already good. And this information should be objective. If, for example, we have a presumption that investigation authorities are too keen on penalizing people who, for example, cannot prove the source of their money. But from the other side, we have to control risks, identified risks in financial sector, and that is normal. But we have to diminish bureaucracy But at the same time, we have to remember that Latvia may not be used for money laundering. We all, Prosecutor General's office, other institutions, state police, we have to work together with private sector, with the society, because only in cooperation through common forums and platforms, we will be able to achieve good results. Thank you. Thank you, Igor Gerasimins from Prosecutor General's office, and similar to first panel, from OECD, we will have a conclusion of a circle. So this introductory part, again, will be from someone not representing Latvian institution. So Amit Kabravala from USA Embassy here in Latvia.
Well, thank you very much for the warm invitation, and I want to personally thank the Ministry of Justice and the Court Administration for inviting me to speak at this very important event. It's commendable to have such an event and bring together such diverse people from institutions, both public and private, to engage in a period of self-reflection and policy planning, and we should definitely do more of that. I've been asked to talk about interagency cooperation in the prosecution of complex financial crimes and what role the state plays in that. Well, the short answer is that the state plays a very unique and critical role in the economic development of Latvia and countries generally, even where there is a strong civil law system of compensation. You know, there's going to be some market disruption. There's always going to be market disruption, and some of that market disruption can be dealt with through the private civil litigation context, and such as shareholder lawsuits, as we see in the United States very frequently. But civil litigation certainly has its limits. At a minimum, it requires well-resourced parties. It requires the ability to collect damages. And in the context of corporate civil liability, shareholders are often unable to hold corporate agents accountable who put their own self-interest above the interests of the shareholders, consistent with their fiduciary obligations. Now, criminal law has the benefit, of course, of threatening incarceration and other sanctions beyond mere civil penalties. This is helpful when an individual or group flagrantly harms the interests of society or the economic interests of a group of people or individual investors. I want to discuss criminal prosecutions and mechanisms that we have used for efficiency. I want to observe at the outset, however, that prosecutions alone are not the solution. Prosecutions must be combined with change in organizational, cultures, and ethics across all areas, both private and public. A cultural shift is only feasible when there are strong mechanisms for corruption prevention, mandatory ethics trainings, and standards of conduct, again, both in the public and the private sectors. So I want to talk about institutional cooperation first, and then I'll talk about an issue that was the focus of the second panel, which was judicial efficiency. I wasn't exactly planning to speak about judicial efficiency, but there were many interesting points raised during the second panel, most of which I agree with. So we all recognize that cooperation can result in better information sharing and more efficient and higher quality investigations and prosecutions. I think we all agree that institutional cooperation is good. So it's not really a question of whether there should be institutional cooperation. It's really a question of how to achieve it. I've worked as a prosecutor for some years now. I'm from New York City, and I focus largely on international money laundering investigations and prosecutions, where we don't actually charge oftentimes the predicate underlying conduct, and we focus largely on the standalone or third-party professionals that facilitate complex money laundering schemes. And so interagency cooperation is fundamental to my job as a prosecutor. Some of the ways in which we achieve this are nothing new. We call them task forces. In some countries, they're called multidisciplinary teams. But really, the concept is bringing together a group of professionals from various sectors of the government, and in some countries, including the private sector, and utilizing the resources, leveraging the resources that exist in agencies. So how do you do it? Well, the one way we form task forces is by asking ourselves questions. Some of the questions that we ask ourselves are, what are the objectives of the task force? Should the goals be narrow? Should they be broad? Should they be geared toward a specific law enforcement priority, such as public corruption task force, or we have one in the United States, the healthcare task force. We have a procurement fraud task force. Or should they focus on a specific region or specific criminal activities such as money laundering? What are the expectations and the time commitments of task force members? What are their roles and responsibilities? How much time will be devoted to task force activities? Should there be points of contact, what we call liaison officers within each government body, that serve as the gatekeepers for information sharing with their particular state agency and other task force members? We found this to be helpful in the United States because we can establish connections with institutions with which we don't have familiarity and from whom we need to get information and records. So sometimes a person is merely a phone call away, and they can help us navigate the system for obtaining records and also let us know what records exist. Communication, information sharing, and record keeping. What would be the rules between prosecutors, police investigators, and sometimes regulators in these task forces? How can information be shared? Must there be a formal process of sharing pursuant to the law? Or can there be an informal information sharing? As we all know, there's the written law, and then there's the practice of that law. And the effectiveness of any law is how it is implemented. So these are some questions that we ask ourselves when we form task forces. Another question we ask ourselves is, what is the chain of command? Who will be supervising the task force? And what are the operational security concerns that need to be addressed? For example, information sharing, and can individual members of the task force share information back to their home agencies, and in what manner? And then, of course, there's the issue of conflicts between task force members and how to address those. These are some fundamental questions that we ask ourselves when we're forming task forces. And one example of such task force would be our suspicious activity report task forces. We call them suspicious activity reports. They're called suspicious transaction reports here. We try to capture a range of activity. And of course, we all know that those are government mandated reports that financial institutions and money services businesses have to file, and other obligated entities have to file about suspicious or potentially suspicious conduct arising from financial transactions. We have well over 100 suspicious activity report task forces around the United States. And that's actually not even that many, given how many suspicious activity reports we receive. And this is a mechanism that's actually provided for in Section 55 of Latvia's own law on the prevention of money laundering and terrorism and proliferation financing. And the Financial Intelligence Unit of Latvia is doing a great job of leading that process pursuant to Section 55 of the law. And what the Suspicious Activity Report Task Force in my district in New York City, what it does is we receive obviously tens of thousands of suspicious activity reports a month. And we call those down and we'll meet a prosecutor, somebody from our Internal Revenue Service, perhaps different agencies that are represented, including the FBI, Drug Enforcement Administration, and other law enforcement agencies. And we'll sit down and we'll farm out, that is, divide up responsibilities for reviewing those suspicious activity reports. And we'll talk about them as a group. We'll meet once a month. And there may be cases that we generate from that. The benefits of having such task force are obviously information sharing, communication between various law enforcement stakeholders, deconfliction, that is, ensuring that two agencies are not investigating the same person or group. And then, of course, there's one of the most important aspects, which is asset recovery, identifying assets for seizure, and to ensure that crime doesn't pay. Finally, I'd like to talk about court efficiency. When we talk about judicial efficiency, this term usually refers to the ability of the justice system to resolve legal disputes fairly, effectively, and competently. The inability, of course, as the second panel members had mentioned, the inability of a justice system to do so is a significant obstacle to the rule of law, attracting foreign investment, and encouraging entrepreneurship. When we talk about judicial efficiency, policymakers frequently refer to the need to install case management systems, electronic filing systems, utilize case weighting systems, and to distribute cases more evenly amongst judges, creating specialized courts, motivating judges to process cases more efficiently by offering a mixture of rewards and punishments, and incorporating different empirical standards. We've heard about that, and those are very, very important ways to create a judicial system that's highly efficient. But what I want to talk about is equally important, and it's about the utilization of existing procedural laws, changing courtroom practices to empower judges to use the full force of the procedural laws that exist, and prosecutorial discretion. No system is perfect. Every system has its shortcomings. So I'll talk about the US system. In the US system, on average, in the federal system, the average criminal case lasts between 6 and 10 months. And it is quite common for complex cases with hundreds of thousands of documents and dozens of witnesses to be concluded with a judgment within 18 months of the initiation of criminal charges by indictment. One of the ways that we do this is really empowering judges to have broad discretion, consistent with our criminal procedure law, which is called the Code of Procedure. Judges use what's called a criminal scheduling order. This is a directive to the parties to ensure that they come prepared. It sets out all of the deadlines pursuant to law and the judge's expectations. And it also makes the parties think about what their evidence is and what the evidentiary disputes are going to be. So for example, you'll have the court set a deadline by which evidentiary disputes should be raised, whether it's dealing with the seizure of evidence or some other issue. So the court can identify those issues early on and address them before they delay the presentation of evidence at trial. We also have status conferences. These are basically check-in conferences to ensure that the parties are progressing with the case. There's also sanctions for non-compliance with orders or failing to appear in court, which I'm glad to discuss at some point, but there is an expectation that lawyers will be prepared, that the parties will show up, and there are mechanisms to ensure that witnesses show up to court as well. These are just some mechanisms that we use to ensure court efficiency, but ultimately it is about a court's power to enforce these mechanisms. Finally, I'll just end with a note saying each court and each case is different, but we have mechanisms that we've developed to deal with cases in a more expeditious manner. For example, we have guidelines as prosecutors on what sorts of plea bargaining that we can engage in and what plea offers can be extended. That if you take the case of money laundering, we will evaluate the amount of money laundered. We'll evaluate whether the money launderer is a professional money launderer. We'll evaluate whether that person held a position of trust, such as a lawyer, and whether that person believed the predicate offense was from a certain category of offenses, predicate offenses like corruption or drug trafficking. These are all factors that we consider when evaluating whether and when to extend a plea offer. And we do this in consultation with the rules that the judges will consider when sentencing a defendant. Thank you again for the opportunity to speak. I welcome your questions.
Thank you. Thank you very much to Mr. Amit Kabravala for framing up the question and on the rule of law. And definitely with that, we are opening up also the discussion. Mēs šobrīd atveram vaļā mūsu diskusijas.
Sí.
So there are several questions. For example, the feeling of not being tried, not being penalized, that one can go away with a crime. So this feeling of untouchability. What are the principles that, how can we mitigate this feeling of untouchability, of being untouchable? Very good question. I forgot to mention in my speech, there are two moments. I will talk from one side as a member of society and as a member of state police. If I speak as a member of state police, it is an obvious moment. We want all crimes to be pursued, all people to be brought before justice, and for the process to be swift. But as a member of society, I want to learn about that. I want to hear about that. Lately, we have investigative journalism a lot more developed. We, as an establishment, as institution, take into account everything that those journalists produce. But there is one problem which I do see as a member of society. In mass media, we often hear about horror stories that lead to nothing, namely that all the institutions are bad. If I were not a police personnel, I would be afraid for my children, for myself. So first of all, I have a question. Investigative journalists do come to us, to the police, and maybe you could give us a possibility to start a process and only afterwards scare the society, telling them that nothing is happening, that we are doing nothing. And from that, this feeling of untouchability rises. It does not correspond to facts. I lead a unit that investigates very big and loud cases. And we have investigated many cases against bank clerks, against insolvency administrators, financial crime groups, and many of those processes have been tried, prosecuted. Igor's from Prosecutor General's office can tell you about Kraibanka case, and there are many penalizing cases. Unfortunately, we as society mostly hear during the news that nothing is being investigated, that criminals can do as they want. And now I will mention COVID. All ministers, including Minister of Health, stresses that we need to listen to verified information, to good information. You shouldn't listen to everything and consider everything to be true. You have to make your own conclusions or base yourself on facts. I will continue what State Police already said. There are three important factors that I could tell you. First of all, swift process, not only in investigative part, but also the trial part, be it privatization question or specialization question or education question. So the process should be very swift and we should get some results. That is first precondition. Fair trial is a second precondition, and it's not connected with one or another type of judgment. There might be acquitting judgment, that is okay, but it is very important to communicate the judgment and explain to the judgment, to the society, that in this case, there were not enough evidence. We cannot try a person who is innocent. And our colleague from the USA already mentioned clear guidelines, very clear guidelines as to which corresponds to a certain judgment. And the certain inevitability of penalization, efficient process which ends with punishment within a certain time frame, that the person is being imprisoned or in any other way penalized. Thus, you get a signal. Everyone else gets a signal that the person is penalized, and that is called general prevention for all other participants of criminal activities. That is from my side. Looking from the US perspective, what are the most important aspects that will help us to eliminate this presumption of being untouchable?
Combat the perception that people are being treated unequally is to treat people equally. As Ms. Giese had said, in the United States, obviously, just like in Latvia, there's equal justice under law, and it doesn't matter who you are. We don't target you because of your high-profile nature, but we don't also treat you especially because of the high-profile nature. Our laws apply equally to everyone. It's the same criminal procedure rules, and we do a thorough investigation as to everyone, because a prosecutor is not allowed to bring a charge unless she thinks that the person is actually guilty and that the prosecutor can prove that guilt beyond a reasonable doubt. And that's the level of burden that we take on ourselves even before we indict. And the second thing is, and again, Ms. Giese had mentioned this, is to ensure that the media really understand and accurately report on cases. So one of the things that I have seen is something we would call a law school for journalists, maybe a 2 or 3 day type of crash course where journalists really understand court procedure and ensure that it is accurately reported, because journalists are good at their jobs. And just like some of the other panelists have said, they can't be good at everything. And so it's important to educate about specific procedures that we use and the sort of the language that we speak in the court system, so that there can be accurate reporting of court cases.
Thank you. Thank you very much. Tagad mums ir jautājumi, kas ir adresēti jau.
Thank you. Now we have questions addressed to specific members of our panel. So to the prosecutor's office, should we not review the prejudiciary issues and should we not divide these issues into subdivisions? Well, the prosecutor's office thinks that these minor crimes should not be allocated as much resources. I think that this is an item that we can discuss because I think many countries, including the US, have set a certain threshold from which litigation is started. Thank you. Now, question to Ms. Giza. How can we ensure that territorial bodies do not take such a long time to decide whether a crime has taken place? Well, we have a very specific answer here. Our new Prosecutor General has unequivocally stated, and I can only also agree that our investigators work with the case from day one. So this applies to both territorial units as well as the main office. We are working in close collaboration with the prosecutor's office, and the Prosecutor General is of the opinion that the prosecutor's office has to play an increasing role in deciding whether proceedings should be started, whether there is actually a case to prosecute. So this would also help avoid these cases that are postponed indefinitely. So in every case, we have a prosecutor, a supervising prosecutor, to ensure that there is no unnecessary delay. However, taking into consideration the amount of work that has to be done by the state police, we expect various support measures to be put in place, including as to how we deal with minor crimes and various other related issues. So here again, it is important to have a public discussion and to help the public understand that the state has limited resources, and unfortunately, we cannot switch on a very complex mechanism, the complex mechanism that is a criminal procedure for absolutely all cases. There are various methods that we can use. We can register the fact, for example, if we have additional information, then we can start a criminal case. So, but these are definitely issues that we can discuss and where there's a lot of room for improvement. Thank you. We also have a question for our American colleague. It actually says in a question for an American colleague, what do you see as the main problem for the court system in Latvia at the moment?
It's a very good question. And the short answer is that I'm still learning. I'm learning every day. And I think from what I have seen, court management should be addressed. That is, how to use the existing criminal procedure law to empower judges to have flexibility and take a reasonable approach to litigation so that each judge understands what the legal disputes will be ahead of the possibility that those disputes would delay the presentation of evidence. And the other thing that I would suggest is for and we can do this as professionals, whether we're judges or not, is to be more proactive, is to prepare, ensure that the parties that appear are well prepared and that everyone is ready to go. And that's really what we would be calling proactivity. That's not something for Latvia, as it is so much in every profession around the world, particularly in the legal sector. So preparation and utilizing the tools that exist in the toolbox of Latvia's criminal procedure law to empower judges to make court proceedings more efficient, and hold people to account that fail to meet those standards.
Thank you. Thank you very much. Nu mums ir pienācis tas
So the time has come for us to end our discussion. So I would like to thank those who sent in their questions, as well as our panelists. And I hope that these discussions will also be furthered, and our interinstitutional cooperation brings tangible results. Thank you to our viewers as well for having joined us from the morning until now. And the statements that we heard today show that we do have a cause for some cautionary optimism, because we saw in all of our panels that we are going in the right direction, that progress is being made. So we can actually congratulate ourselves a little bit. It's not all as bad as we sometimes tend to think it is. We are in the right direction. And of course, there are still various crucial issues that are related to our personal courage within the system, as well as seeing laws as a value, and overall the ability to cooperate among ourselves, basically respecting each other, respecting other institutions, and respecting ourselves. So thank you for being with us today. Have a wonderful rest of the day. Thank you.